Right, welcome back to New Day. It's now time for the Chamber, and this morning we're looking at the issue of alternative dispute resolution. And alternative dispute resolution has been considered as the most effective way of resolving conflicts, especially family conflicts. And court settlement is seen as cumbersome and does not lead to peaceful coexistence. Godfred Tanam looks at the relevance of ADR.
The principles of alternative dispute resolution have been in existence in Ghana dating as far back as the pre-colonial days. These principles have been part of various traditional norms and values of the Ghanaian societies. Most disputes in the past have been resolved through extended family systems. With the establishment of the nuclear family system, resolving disputes have been a major challenge. Most conflicts in families have resulted in divorce. Veronica Dampton, a fashion designer, is a victim.
I had a problem with my ex-husband, that's my spouse. We had a problem with a piece of property that we all built together. I was in the house not knowing the property had been sold already. This created very big conflict.
What has been the impact after going through the alternative dispute resolution?
I met one lawyer who treated me so well, followed me to the court, went out with all proceedings at the court without taking a peso from me. I just asked myself, what is happening? Because I didn't have even a peso for transportation to Legal Aid Board. I have to walk from La. I realized the Legal Aid Board really helped me out freely. They didn't collect any money. And at the end of 1 month, I was able to collect half of the monies accrued from the property sold by my ex-spouse.
Regina Datson, a beautician, had to raise 5 children by herself.
With 5 children, it's not easy. And I'm a beautician, but my shop too got spoiled, and I have a shop too and the streets, because they are doing a new street, so my shop too were destroyed. So actually I'm not having any money. So what I do is that I pick some of my clothing and take it to Kaneshi Market to sell them before we can feed.
The conflict between the husband and her put fear in the female children especially.
My girls, it got to a time that any man they are afraid of because of the way the father treats them. Anytime they see their father, they are afraid. Because even if you are not wearing slippers, he's going to beat you.
A member of the Federation of Women Lawyers, Jenny Quay, says conflicts are not well managed at the family level, which gives reasons why mediation is important. She believes the best way of resolving family conflict is to use mediation and alternative dispute resolution instead of opting for court settlement.
Conflict is real in the home. We know that in Ghana, 1 in every 3 women has suffered one form of abuse from their partners. Conflict is not being managed at the family level enough for it to, for us to find solutions, because it will start like just a small minor thing, a few insults here and there, psychological abuse and so on, and then before we know, the person is in the psychiatric hospital.
Right, you're still watching The Chamber here on New Day, and this morning we're looking at the issue of alternative dispute resolution, and my guest is Mr. Martin Nwosu, who is the former director at Legal Aid and also happens to have been my lecturer at the law school. Good morning, sir.
Good morning.
It's good to have you here.
Nice to see you, Sandra.
Nice to see you too, sir. Now, litigation was handed down to us as a form of dispute resolution since colonial times, but even before then we had our own traditional ways of resolving conflicts. So what exactly is ADR and how did it come about?
Well, ADR, as the term goes, means alternative dispute resolution. Now when you talk about alternative, is not alternative in the sense of supplanting court process, but it's an additional mechanism or processes of resolving dispute, if you like, more effectively. So yes, litigation, the court system is there, but it's faced with a lot of problems. So you go to court with a very simple issue. For a very long time, this problem will still be pending. But with alternative dispute resolution, we try to look at the nature of the conflict or dispute and try to fashion out the appropriate mechanism for resolving it at the least expense and then as quickly as possible.
Okay. There's no doubt that litigation has lived up to its name of, structuring society. But has it been able to live up to its role in democracy?
Well, it's a yes and no answer, because when you talk about courtroom litigation, there are pros and cons. You've talked about some of the advantages. Let me talk about some of the disadvantages. One, in terms of relationship, courtroom litigation always destroys whatever relationship you may have.
Because it's very
acrimonious, very aggressive, and the parties involved, the way the courtroom is set up, are not given the opportunity to really say what it is that bothers them, to air their views, to ventilate, if I may use an ADR word. Exactly. But where people have the opportunity to negotiate, to talk effectively, engage with each other, really understand the concerns of each other, then they can get to the bottom of the problem and have it resolved effectively.
And even courtroom language can also be very daunting.
Exactly.
But when it comes to ADR, it's broken down.
All those languages frighten litigants. And most time when people go to court, you see them chasing after their lawyers, ask them, so what happened? I wasn't given the opportunity to talk today too. When am I going to speak? When people have problems, they are like sick people. They are looking for the earliest opportunity to talk about their problem. But because of the processes and procedures involved in courtroom litigation, you have to go through it step by step. So a small problem, you can go to court for 3 to 6 months, you haven't had the opportunity to speak. Right. Whereas in ADR, mediation for instance, the very day you take your matter to the process, you'll be given the opportunity to talk about it. Right. And that in itself is very healing.
Right. So the process is shorter, the cost
less
is
expensive, also very friendly. People are given the opportunity to say their own thing. And at the end of the day, the resolution that is achieved is the way the parties want it, not an imposition by the court. People go to court, sometimes you may even win the court case, but you look at it and you realize that your real need in the particular matter has not been satisfied. Exactly. So the loser is not happy, the winner is not happy. Then who gains at the end of the day? Is it the system? I doubt.
Okay. So what are some of the various means of, various forms of ADR?
Now with ADR, we start with negotiation. And negotiation is where two people involved in a problem have the opportunity to talk about it themselves.
Just the two of them?
Just the two of them.
There's no middleman.
You don't even need an intervener. That is negotiation. And we do this every day.
And are people able to come to settlement with?
Sandra, the fact is that we do it every day. You go to the market, you are buying tomatoes, you are negotiating with the tomato seller. In the lecture room, you are negotiating with your lecturer. Because if you don't understand anything, you ask. So there and then, and that is a form of resolving a conflict. Because the student is in the classroom to pass her exams. If she doesn't understand what the lecturer is saying, how is she going to pass? So she had to act. That is negotiation. At the family level, parents always engage with their children. They find out what their concerns are. Husband and wife the same. But the problem is, because we haven't learned how to probably talk effectively, sometimes the way we talk can breed a problem.
But who will be that middle man there to, sort of calm tempers and, like you said, let us know how to talk to each other? So that can just two people who are on opposite sides be able to come together?
So where they have failed, what we are encouraging is that when you have a problem with a friend, go discuss it with a friend. In the family, father, mother, children, talk about it. Where that doesn't help, where the problems are not resolved, then you look for a third party. This is where mediation can kick in. And what mediation does simply is this. It creates a forum with the help of the neutral person or the intervener, the mediator, to bring the two parties together, facilitate the discussion process between the two parties. So what he's doing is to have the parties negotiate.
So this person doesn't take sides?
He doesn't take sides. No. He just, by use of questioning, effective questioning, he helps the parties to bring up their various concerns. And also encourage them to listen to each other. Because communication is a two-way affair. The talking and the listening. But human beings, what we are, even though we have 2 ears, which means we should listen more effectively, we are always in a rush to talk rather than listen. And that can create a problem. Because if you don't understand what your colleague is saying, you'll not be able to respond effectively.
Right. So the mediator just facilitates
the discussion, the process.
Okay.
All right. That's what the mediator does.
Okay.
So we talked about negotiation, we talked about mediation. The third process is arbitration. Well, arbitration is like court process, but the difference is that in an arbitral process, the parties have the opportunity to choose who their arbitrator should be, where the process should be held.
What if they are unable to agree?
They have to.
You want this particular person, I want this particular
person.
At
the end of the day, they'll have to.
There'll have to be an understanding.
That is why the arbitrator is there. Okay. The arbitrator functions like the mediator, but at a certain higher level. Because in the case of arbitration, after listening to the parties, the arbitrator will have to come out with a decision, which is normally called an award.
And is this decision binding?
It is binding on
What about the rest of the other processes? We talked about negotiation and mediation. Are the decisions that come up also binding on both parties?
Mediation is binding in our country. In Ghana, there's an interesting situation because the ADR Act made provision for the binding nature of mediation agreement.
So there is a law that governs
the process. There is a law. ADR. We have the ADR Act 798 of 2010, and it has set up the various processes. And interestingly, it even talks about customary arbitration, so that at the lowest level of our society and community, people can still have these customary arbitrators. You know, our forebears have been relying on customary arbitration for so many years, and this had been codified. So that if you have a problem, you don't always have to run to the court. Now, there are various mechanisms that we have spoken about that can help have the problem resolved.
So is ADR then, is it mandatory? Is it compulsory?
At different levels. Okay. ADR is not compulsory. You have to encourage the party. They have to agree.
Who encourages the parties? Is it the courts? How does it come about?
Interestingly, again, in Ghana, we have what you call the court-connected ADR. So now, in the court's own wisdom, when you file a matter in court, they can look at the nature of the case, and the judge can say, gentleman, lady, or friend, why don't you try ADR? He will
can you refuse?
You can. It's an encouragement.
And say, Your Honor, with all due respect, I don't want ADR. Let's just go ahead.
And that ends it.
Okay.
But interestingly, when people have tried it, they have always loved it, because they see that it works very, very effectively. And at the end of the day, they are able to understand. You see, in life, there are a lot of perception. People take decisions on the basis of perception, whether rightly or wrongly. But when they speak to each other, then they are able to understand and have answers.
I think at the end of the day, that's what it all boils down to, understanding, communicating and understanding. Yeah. Well, we've talked about all the good things, the advantages and merits of ADR. Are there any challenges at all facing ADR?
The challenges, one, has to do with education. People have to understand that this is another process that should work. When people come to see lawyers in their chamber, they always tell them, I have this problem, I want you to sue this person. When you talk to them about other processes, they don't seem to understand. So the encouragement is for all of us to be involved in this education program, to let people know that many, many problems can be resolved without recourse to litigation, and very quickly, and have the relationship restored, especially family dispute or conflict.
Like we saw in that short clip there.
So in that clip, you realize that because the women did not have the opportunity to talk with their husband, the marriage had to end. Right. But if they had had the opportunity to talk, probably they would have salvaged the marriage.
Right. Has ADR gained acceptance in Ghana? Do you see that a lot more people are more affable to settling out of court?
The progression is very interesting, because from the statistics that we receive from the court, a lot of cases are being resolved through ADR, especially at the district court level, up to the circuit court. When the references are made, people love it.
But what kind of cases generally go to ADR? Because I would imagine that maybe some of the very acrimonious cases, or the ones that are very adversarial in nature, like land matters and things, would somebody want to go and sit down? If somebody has stolen my land or taken my land, would I want to go and sit down and negotiate? I just want my land back.
That's interesting. So we do admit that not every case is amenable to ADR. Where you see cases involving relationship, father, mother, husband, wife, parental, children, or landlord, tenant, employer, employee. These are people who have a certain essential relationship that should be sustained and enhanced. But if it is not managed properly when there is a dispute, which are inevitable, because conflict and dispute are part and parcel of our human life, they will come every now and again. You know. So because of the question you asked about what type of cases, yes, we emphasize family dispute, landlord, tenant, and stuff like that. And because of that, one of the associations that I represent, GACMA, Ghana Association of Certified Mediators and Arbitrators, have in collaboration with the Ghana Bar Association designed a very interesting program, which is to help families resolve their dispute or conflict. So that is one intervention. Because if you go to the courts, for instance, you see that the rate at which marriages are being dissolved is very, very alarming, very discouraging. And most times for very petty reasons, which if the parties again have sat down and talked about it in an effective manner, they would have resolved it.
Okay, finally, we're out of time, Mr. Nwosu, but finally, do criminal cases, as a provision made for criminal cases to undergo ADR?
Yes, a certain type of criminal cases can go through ADR. In fact, the Courts Act made provision that when you have minor criminal matters, what is called misdemeanor, petty assault, attending, yes, they are criminal in nature. But if you look at the relationship involved and the level of the offense, they can be resolved.
Is that what you refer to as victim offender?
Victim offender.
So we are not talking about murder, manslaughter,
and those ones must necessarily go
through the process.
Exactly.
All right. Thank you very much for your time this morning. We are out of time. My guest this morning has been Mr. Martin Nwosu. He's the former director at Legal Aid and also happens to be my lecturer, or was my lecturer at the law school. I'm not in law school anymore. This has been the Legal Desk, known now as the Chamber. We've been talking about alternative dispute resolution.